Section 7. The Standard of Care. Introduction. Agency is not just about forms. In the earlier sections, we discussed how agency relationships are created, disclosed, documented, and managed. We talked about REID, buyer-broker agreements, compensation, limited representation, confidentiality, and real-world legal hotline issues. Now we move into one of the most important ideas in agency law, the standard of care. This section answers a simple but powerful question. What level of professionalism is expected from an Arizona real estate licensee? The answer matters because agency is not just about having the right form signed. It is about how the licensee performs the job. What does professional really mean? A professional is someone who has special training, education, licensing, and responsibility. We expect doctors, attorneys, accountants, and engineers to perform their work carefully because the public relies on their expertise. Buyers and sellers rely on real estate professionals to guide them through major financial decisions. They expect licensees to understand contracts, disclosures, deadlines, negotiations, property issues, and agency duties. The course material explains that a professional must provide services consistent with the standard of care in the industry. The standard of care explained. The standard of care means a real estate broker or agent must act with the level of care that a reasonable broker would use in the same or similar situation. In simple terms, the question is, would a reasonably careful Arizona real estate professional have acted the same way? If the answer is no, the licensee may have fallen below the standard of care. The course material explains that a broker complies with the standard of care by performing duties with reasonable care and skill. It also references Vivian Arnold Realty Co. v. McCormick, where a listing broker was expected to exercise reasonable care to sell the seller's property at the best price and terms. It also references Haldeman v. Gosnell Development Corp., which stated that a broker must exercise reasonable due care and diligence to benefit the principal. Real-world example, the listing agent who just guessed. A seller asks an agent, "What should we list the home for?" The agent quickly says, "Let's list it high and see what happens," without reviewing comparable sales, market conditions, property condition, location, or buyer demand. That may sound harmless, but pricing is part of professional care. A listing broker should use reasonable skill and market knowledge to help the seller make an informed decision. The agent does not guarantee the final sales price, but the agent should not simply guess. Standard of care for listing brokers. A listing broker's standard of care may include properly pricing and marketing the property, reviewing disclosures, responding to offers, communicating with the seller, and negotiating in good faith. For example, if a seller receives an offer and the listing agent waits several days to present it because they are busy, that may create a serious problem. The seller may lose an opportunity, and the agent may have failed to act with reasonable care. A professional listing agent should be organized, responsive, and careful with deadlines. Standard of care for buyer's agents. A buyer's agent also has important duties. A buyer's agent should help locate properties, explain contracts, discuss red flags, recommend inspections, communicate known material facts, and guide the buyer through the process. For example, if a buyer says, "The roof looks old, should I be worried?" The agent should not say, "Don't worry about it," unless the agent is qualified to make that judgment. A better answer would be, "That is a good concern. I recommend you have the roof evaluated by a qualified roofing professional during your inspection period." That response protects the buyer and keeps the agent within the proper role. Rules updated, licensee duties, and reasonable care. The updated Arizona rules continue to emphasize professional conduct, competence, and reasonable care. Under R4-28-1101, a licensee must deal fairly with all parties and avoid fraud or dishonest dealing. The rule also requires licensees to perform duties competently and within their area of expertise. If a licensee lacks experience in a certain type of transaction, the licensee should seek guidance, recommend professional assistance, or decline work that is outside their competence. The course material also explains that a licensee must exercise reasonable care in obtaining and communicating information material to a transaction. Reasonable care depends on the situation. Reasonable care is not exactly the same in every transaction. It depends on the facts. A first-time buyer may need more explanation than an experienced investor. A rural property with a private well may require different guidance than a condo in a master-planned community. A commercial lease may involve different risks than a residential resale. A property with visible water damage may require more caution than a newly renovated home with no obvious concerns. The standard of care adjusts to the situation, but the licensee's responsibility does not disappear. Case law, Lombardo versus Albu. The course material references Lombardo versus Albu, an important Arizona case involving broker duties and disclosure. In that case, the court recognized that ADRE rules can help establish the standard of care, including duties involving disclosure of information that may affect a party's ability to perform. This is a major lesson for agents. Rules are not just classroom material. They can become the measuring stick in a lawsuit. If a licensee ignores agency duties, disclosure duties, or professional conduct rules, those rules may later be used to show that the licensee failed to meet the standard of care. What happens if an agent falls below the standard of care? If a broker or agent falls below the standard of care, the result may be negligence. That can lead to legal liability if the conduct causes harm. For example, if an agent misses a deadline, fails to communicate a material fact, mishandles confidential information, or gives advice outside their expertise, the client may claim they were damaged by the agent's conduct. The plaintiff generally must prove two things. The broker's conduct fell below the standard of care. That conduct caused harm. Who decides whether the standard was violated? If a dispute becomes a lawsuit, the trier of fact decides whether the broker fell below the standard of care. The trier of fact may be a jury, judge, or arbitrator. Often, expert testimony is used. Another qualified broker may testify about what a reasonable broker would have done in the same or similar situation. That means the real estate industry helps define its own professional expectations. Real-world example, the agent who overstepped. A buyer asks, "Do you think I can build a guest house on this property?" The agent says, "Yes, absolutely," without checking zoning, HOA rules, setbacks, septic capacity, permitting, or county requirements. Later, the buyer learns a guest house is not allowed. That agent may have created risk by giving an opinion outside their expertise. A better response would be, "That depends on zoning, permits, HOA restrictions, utilities, and other requirements. Let's recommend that you verify this with the county, the HOA, and any appropriate professionals before moving forward." That is reasonable care. A strong agent stays educated, follows broker policies, uses current forms, documents conversations, recommends qualified professionals, and asks questions when unsure. The course material reminds brokers and agents that quality education and professional development help maintain a high level of professionalism and reduce legal liability. The best agents do not wait until something goes wrong. They build good habits before problems happen. The big lesson: the standard of care is the professional measuring stick. It asks whether the agent acted like a reasonably careful, competent real estate professional under the circumstances. Agency disclosure, buyer-broker agreements, confidentiality, compensation, and legal hotline issues all connect back to this same idea. Real estate professionals must act with care, skill, honesty, and competence. As we move into the next section, we will continue building on this foundation by looking at how agency duties show up in everyday conversations, client questions, and transaction decisions. Online discussion questions. Question 1. What does the standard of care mean for a real estate licensee? Answer. The standard of care means a licensee must act with the level of care, skill, and diligence that a reasonable real estate professional would use in the same or similar situation. Question 2. Why should agents avoid giving advice outside their expertise? Answer. Agents should avoid giving advice outside their expertise because it may create liability if the advice is wrong. Instead, agents should recommend qualified professionals such as attorneys, inspectors, lenders, roofers, surveyors, or tax advisors. Question 3. How can ADRE rules relate to the standard of care? Answer. ADRE rules can help establish what conduct is expected from a licensee. If a licensee violates professional conduct rules, those rules may be used to show that the licensee fell below the standard of care.